sign they use for warnings and, Amber Alerts and all that. It said, be careful of increased deer traffic or deer, and if I'm lying, I'm dying. There was a dead deer right there at the foot of the sign on the bridge, and it was like Exhibit 1.
I dropped a little Kia Soul, bulldozer, and I was coming down. I live in Winston, I was coming down the highway, and there was a deer, so I swerved and missed the deer, and there was another deer right there. I had to straddle it, and the whole car was
Just to let you know, the way the timer works in the state, it will start at 30. It will count down to 0. At 0, you're done. At 2 minutes, the yellow light will come on to give you a warning that you're getting to that point as sort of an additional visual warning that you're getting to the end of your time. Okay. Do you have my cell phone number?
I don't, but I don't have my cell phone anyway, so I got the email.
All right. Well, then I'm going to leave you to it. I think
Okay.
we're good.
All right.
And yeah.
We'll see you when.
Email if you need anything.
Okay, I sure will. Thanks, Gene. These your pins? These are not your pins, are they?
No, we're just leaving those there for extras. Yeah.
Great.
Until we get through swearing in.
Okay. Cool. We got two. One. One. Okay. One. All rise. The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes, the Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Good afternoon. Welcome to your North Carolina Court of Appeals. My name is Judge Chris Dillon. I'll be presiding. To my right is Judge April Wood, and to my left is Judge Fred Gore. We have one case on the calendar. It is State v. Hahn. And if the appellant is ready, and just let me know if you want to reserve any time. I'll keep your time up here and give you some warning, give you your 5-minute warnings and things like that.
Yes, Your Honor. I would like to reserve 5 minutes for rebuttal.
Okay.
May it please the court, my name is Jason Yoder, and I'm here representing Mr. Travis Christopher Hahn in this case. And the issue in this case is, the central issue in this case is very simple. Could Mr. Hahn be arrested for trespassing while he was on a public sidewalk in downtown Asheville, as the state alleged in its indictment in this case? The answer to that question is no. Our second-degree trespass statute requires an individual to be on the property of another. It's intended to protect private property interests, not be a mechanism for the arbitrary ejectment of people from public sidewalks.
Counsel, where are we at on that very issue, on the ability for that public consent that is extended to public citizens and our case law allowing for that consent to be revoked based upon conduct by individuals? Where are we at with the case law as it pertains to that?
Well, Your Honor, in my research, I did not find any cases that squarely allowed trespass to be applied in a situation like this. A public sidewalk that's open all the time, that's filled with hundreds of people on any given night in downtown Asheville. There may be instances where public lands, you could be trespassed off of them. Obviously, this is a public building, but a person could be trespassed out of this. But I don't think you could be trespassed off the front sidewalk of this building. And that is essentially what the issue is in this case. The criminal trespass statute was simply never intended to be applied in this type of a manner.
What if the restaurant were to have, say, tables sitting out front in their curtilage? Would you then say that the restaurant has the ability to tell people who can and cannot be in that area for the purpose of dining at that restaurant?
Well, Your Honor, that issue actually came up in this case because there are some businesses in downtown Asheville which apparently have a right to put tables out. This restaurant is actually not one of those. If you look at the video and if you listen to the testimony, there's nothing where Mr. Hahn was standing the entire time. It does have an outdoor terrace area, but if you look at the video, which you've probably seen, it's gated and entirely separated from the public sidewalk area. So, and I also would take issue with the word curtilage. It's a very technical legal term, and even though the police officer testified they had curtilage, I don't think legally there is such a thing as curtilage on a public sidewalk. Curtilage is a very narrow legal term by the United States Supreme Court to talk about the space surrounding a person's domicile. And businesses are not entitled to the same expectation of privacy that a public home would have. A police officer can obviously walk right up to a business front. That would be a violation of curtilage if it was a home, but it's not curtilage if it's open to the public. An open field and a curtilage can't exist simultaneously. So I think under certain circumstances, a restaurant might have a private property interest in the sidewalk if they had been granted that authority somehow. But in this case, I don't think they do.
I was trying to understand just the trespassing part, irrespective of where your client was. What was the state's theory as far as why he was trespassing? Did the pizzeria ask him to leave, or does, I mean, what was the evidence in light most favorable state as far as the lack of consent to be there? Why did this police officer feel like he needed it?
Well, I think this
He was an off-duty police officer and he working for the.
He was an off-duty police officer, and I think one of the issues in this case is that he was really trying to vindicate a private property interest of the pizzeria, when he didn't really have authority to do that on the public sidewalk.
Would he have if the guy had entered the restaurant?
Absolutely. You can enter a restaurant, of course, you're entitled to do that the first time, but you can be ejected from any public area within a business after that. But you're entitled to go in on the first time at the very least, because it's open to the public.
After he was
That
told,
license can be withdrawn.
after he was told not to come back, did he come back and put his face against the window, or was there evidence in light most favorable state as to that?
I think the evidence is that he peered through the window. I don't think the evidence is that he pressed his face
Or he never
to
got
the
off,
window,
or that he ever got off the sidewalk to do so?
or that he ever got off the sidewalk to do so. But even if he became close, which is essentially the state's theory on appeals, that he got close enough to trespass on the private property, I don't think you can get close to trespassing. You can either trespass or you don't trespass on private property. And I think under these facts, there was insufficient evidence that Mr. Hahn ever actually trespassed on the private property of the pizzeria in the light most favorable to the state, which is the standard that we have. And obviously, the jury agreed. Ultimately, they acquitted him of trespass. And they didn't believe that the facts here could be proven to their satisfaction, the reasonable doubt standard, that a trespass occurred in this case. And I recognize that
Trespass requires you actually occupy, that it's not enough to be a nuisance to some, if you're creating a nuisance for some restaurant, even though you're off-site by making loud noise or whatever, you're asked to stop doing it, that's not enough for trespass. That'd be a different crime, perhaps.
I mean, in theory, bothering a person is not a crime that I could find in the general statutes. Being a nuisance, being an annoyance, being a mentally homeless person, these aren't necessarily things that amount to crimes, and they're certainly not elements of trespass.
Well, I guess the question then, counsel, is irrespective of the reasonable doubt standard that the jury found, does the conduct by the defendant warrant interaction if requested by the pizzeria? Was the interaction lawful to engage with the defendant? Let me ask you that.
Well, certainly we assert that the arrest was unlawful.
Yeah, well,
That's the foundation of our case.
I hadn't gotten there yet. You, sir, my specific question is the interaction with him to start engaging with him. So I guess I'm taking it a step back before the arrest piece.
Mm-hmm.
So would it not be true that the initial contact based upon the request of the pizzeria to the off-duty officer for them to engage, are you saying that that initial interaction was unlawful? Because I hear you're saying that the arrest was unlawful. But what about the initial interaction to start engaging with the defendant?
Well, I think that a police officer has the right to communicate with people who are walking on the sidewalk until you're seized. That's a consensual encounter of some kind. And so obviously the officer can tell you to move. You don't have to move if you're not trespassing. He can't tell you to do something that you don't have a legal obligation to do. And so if he doesn't have authority to eject you from the sidewalk, the essence of a trespass is missing. Because ejectment is sort of the essence of like what a trespass really is, an interference with an actual property interest. But in terms of your question, of course, the pizzeria can ask the officer to move people or even eject them from the sidewalk, but that doesn't make it lawful because the pizzeria never had the authority to eject people from the sidewalk to begin with, at least under the facts of this case. And we touched on the facts of the trespass itself, and I would just like to touch on very briefly that the client clearly, in this case, his lawyer detrimentally relied on the indictment in this case, which alleged a specific crime for arrest. And under State versus Silas, our North Carolina Supreme Court has said that even when an element is not essential, a defendant is entitled to rely on the theory of the case as stated specifically by the state in its indictment. The state did not need to allege the specific reason why the arrest occurred in this case. They did so, and having done so, the lawyer was entitled to rely on that in terms of framing the defense. And it's clear in this case that the defendant solely relied on this theory as a defense. That was the entire theory of Mr. Hahn's case, that the arrest was unconstitutional, therefore there was no resistance, therefore there was no assault, and therefore there was no malicious conduct by a prisoner. And I recognize that shortly after the briefing was completed in this case, this court ruled in Tarleton that this allegation would be inessential. And in terms of that case, I think this is a very different one. There was no evidence in Tarleton that the defendant actually relied on the variance in terms of their motion to suppress. And indeed, Tarleton probably waived his argument altogether when the defense lawyer specifically requested a jury instruction on an offense that was never alleged in the original indictment. So respectfully, I think Tarleton, it doesn't apply in this case, but also the essence of its holding is questionable in light of State versus Silas and some of the other North Carolina Supreme Court cases holding that you have this due process right to detrimentally rely on the indictment when you're preparing for trial.
Counsel, as we step back and dealing with just the initial charge, you stated Silas. How do we reconcile Silas with State v. Nickens, in which the court uphold a denial of the motion to dismiss for a defendant who entered a DMV here in North Carolina, and which he lawfully could do, but ultimately became belligerent and was cussing, and that consent was withdrawn by basically an agent representative for him to remain there. And so how is it not analogous to this case, where the defendant in this case apparently was requested to leave the area? He did so. He came back, made utterances to patrons. He cursed loudly, refused to move along, and this went on for about 30 to 45 minutes. How is it not that the defendant has given up that public access or that consent that is extended to him as a public person on that area, when, you know, someone who does have a business interest in that area has asked them to move along, or that representative, analogous to Nickens? How do we separate those two?
Well, in Nickens, I believe the defendant was inside the actual building, and of course here there's no evidence that the defendant ever actually went inside the pizzeria.
Well,
the pizzeria is trying to eject a person from somebody else's property.
I'm saying on the public ground standpoint, because I think we all would agree that DMV is a public building. I don't think there's any private interest by DMV. Some might argue that, depending upon how they're paying fees to
Sure.
DMV. But in the grand scheme of it all, DMV is public. The sidewalk's public. So how do we reconcile the public stance of those two? I know it's inside four walls, inside the building, but it's still a public space. How do you reconcile that being a public space?
Well, I think that obviously a government agency has some independent authority to control its private property. It's actually owned by the government. And the sidewalk here, as opposed to the DMV.
Not the taxpayers?
No, I don't think it is owned by the taxpayers per se. This is an argument you see, that I can tell you what to do because I pay your salaries. That's not a sensible argument. It's not your building because it's actually, the rent is paid for by the government. And so I think that's a very different situation than being trespassed off a public sidewalk, where everybody has an indefinite license to go to and from and sit and protest and do all kinds of different things. So the factual issues are very different. I did do a nationwide search on this, and I could not find any cases where a court held that you could be ejected from a public sidewalk. I did find the cases that I supplied you with very similar statutes saying that you could not be ejected from a public sidewalk. But whether those cases exist, I don't know, but I couldn't find them in my search.
What about, I'm just trying to think, if I have if I'm this pizzeria, do I have a pertinent interest into in the sidewalk as far as ingress and egress inside my pizzeria? And if somebody's blocking it from the public sidewalk, could that be deemed a trespass? If you're blocking people's means of going in and out? Or maybe I'm just thinking.
No, and that's a good question. And that happens all the time with abortion protesters who lock themselves to the doors to prevent people from getting access to clinical services. But that, I don't think...
Is that a trespass?
It might depend on where you are factually in terms of the property. Typically, a clinic is set back on a private property, so you're trespassing as soon as you cross the sidewalk threshold. But it could be another offense that's not trespass. The trespass property it's narrower than trespass at common law. It's not a tort. It's a criminal statute that specifically requires you to enter or remain on the premises of another. You have to actually be on the premises to trigger the criminal trespass statute. And I think if you change yourself to a door,
What if
you might not qualify for that.
If I just get a bunch of people in front on a sidewalk and just block I mean, certainly people could go around me in a very awkward way, but could that be a trespass if I'm blocking the door? If I'm standing on the sidewalk and get a bunch, I'm just trying to think of a theory. Is that possibly a trespass or is it not because I'm not on the premises?
Well, I think it's not a criminal trespass because you're not on the premises. It might be some other kind of offense. It might be that the pizzeria would have a tort against you for interference with their possessory rights to their own property, but it wouldn't rise to the level of a criminal infraction under our laws. But I think
how would you be violating the possessory rights of their own property if you're not on their property?
Well, if you limit a person's ingress and egress to their own property.
Well, could this police officer reasonably believe that the law of trespass would include that? Maybe he's mistaken. State v. Hahn, he's just mistaken, but he might have thought reasonably that, well, if you're blocking someone's ingress and egress, you're actually trespassing on their property and make that mistake. And we don't really have a case that says one way or the other. Is that a reasonable mistake to make?
Well, I think that's not a reasonable mistake to make in light of Hahn.
Well, you just said a tort was in possessory rights. I'm just trying to think, if that's a possessory right of ingress and egress, why wouldn't, isn't that what trespass is about, is interfering with somebody?
Trespass is specifically and narrowly defined by statute. It's not a common law offense any longer.
We lawyers may know that, but would a police officer know that? I don't.
Well, you would hope a police officer would know what the trespass statute is, and it's probably one of the statutes that they enforce
Same with the
most
taillights.
often in downtown Asheville. But to your question about Hahn, I don't think that this is a reasonable mistake of law, if that's what you think it is. Or you think that's an issue in this case. I think that there is no reasonable application of trespass to the facts of this statute. And aside from that, I think that, resisting arrest, there's never been, as far as I know, a case where it would say you can't resist an unlawful arrest because the police officer reasonably believed the arrest was lawful, but it wasn't. The question is essentially whether it's lawful or not.
On that issue, have you reviewed State v. Jeffries from our Court of Appeals? And in their evaluation of, in essence, the essential part is the reasonableness of the officer's belief. Have you evaluated the ruling in State v. Jeffries?
Well, yes, actually, Jeffries and Bradley, they're decided one after the other. It was kind of essential to his defense, because in Jeffries, I believe it was this court actually held that when the reasonableness of an arrest is an issue that factually should be determined by the jury. And so in this case, the jury was instructed on the reasonableness of the arrest. And
But doesn't that get us beyond whether the officer's conduct was reasonable, and then gets to the level of resistment, or resisting by the defendant? Looking at Jeffers?
yes, if the arrest was unlawful, then the secondary question is whether the resistance was proportionate to the unlawful arrest. You're correct.
So the officer is reasonable in his belief that he's got the right to arrest, but he's wrong. For this crime of resisting arrest, do we look at it from the standpoint of the officer or the defendant, as far as, because the defendant may think this is totally unreasonable, or the officer's mistaken about something and he may be right, but if the officer is subjectively in good faith believes it's okay, I'm just trying to think, would this defendant be guilty of this crime? Because there's no way he can know what the officer's subjectively thinking.
I don't think the officer's subjective belief in whether a crime occurred is actually an issue here, or whether the law actually applies.
Or is it objectively reasonable to think that the officer objectively reasonable in thinking that a law, and that's right, subjective doesn't matter, whether it's objectively reasonable. Okay.
So, Mr. Yoder, as I understand your argument is because you contend that there was not a lawful arrest for the trespass, that therefore the defendant could not be convicted of any of the other offenses that followed thereafter, but he was also charged with resisting the officer, but then further he was charged with and convicted of assault on a government official for kicking the officer.
That's right.
And then the malicious conduct by a prisoner for spitting on the officer. So what is your position on that, if in fact the officer did have the right or the belief he was trespassing, even if it were mistaken?
Well, a defendant who is arrested does have a right to resist an arrest, and I think the fighting in this case was the resistance to that unlawful arrest.
You can't pull a gun out and shoot the police officer.
He can't pull a gun out and shoot the police officer. That would be disproportionate to the arrest.
But kicking it
Although
in the
potentially
groin-
if a police officer was shooting at you, you could fire back and you would have a self-defense claim because there would have been an unlawful arrest. But your resistance has to be proportionate. And here, I do think it was a proportionate resistance. And it was a continuous resistance. This is the fourth issue in our case that we haven't really touched on, but our Supreme Court has said when the same conduct is involved in a case, you can't be sentenced to both assault on a government official and resisting arrest. Yeah. And here, yesterday or the day before, I filed a memorandum of additional authority because our Supreme Court clarified what actually constitutes continuous assault in that case. And I think those facts, when applied to Mr. Hahn's case, show that he was wrongly sentenced to both of these offenses at the same time.
You have about 3 minutes before you eat into your 5 minutes. Just wanted to.
But as to Judge Wood's question again, because I'm going a little circularly, if the detention itself was unlawful, there is no malicious conduct by a prisoner because you're not actually a prisoner if there's no lawful detention. And the same would be applied to the resisting and to the assault on a government official case.
Get me to the equilibrium of the level of arrest and level of assault. Get me to where they're equal in his level of resisting. Because I didn't read it. I might be wrong. I'm being facetious here, but I don't hear any facts where they kicked him in the leg. So get me to where they're equal.
Well, they're obviously forcing him. They're manhandling him. All three large men are on him. They have him in a chokehold. I don't think that the law says you have to be kicked in order to kick a person back. The type of resistance is going to depend on the type of force that's being used. And if somebody has you in a chokehold, it may be your only form of resistance is to kick with your legs because your arms have been immobilized by the chokehold.
I guess I'll ask the state this, that I don't know if the jury found that it was reasonable one way or the other. They said that he was under arrest and so that he couldn't resist at all. But your theory is that if we find that he wasn't under arrest, the jury was never really asked, was it proportional or out of proportion, the response, I
Well,
guess.
and that is a question that would be up on a potential remand if this case would go back for a new trial or something like that. And I see that I have 6 minutes left.
Yeah,
I'd like to
take
reserve
your-
that time
that's fine.
unless any of you have further questions.
That's great, thank you.
Thank you.
May it
Afternoon.
please the court, I'm Patrick Wooten from the Attorney General's office. We have spent 24 minutes discussing what is supposed to be clear to an officer on the street. Probable cause deals with probabilities and not certainties.
And does it have to be probable cause that a trespass occurred, because that's what you allege in your indictment? I'm going to get that part first.
Yeah, I believe it does. I mean,
Okay,
that's
so-
pretty
okay, that's just-
clear. So, I mean, and that is, and there was some indication in the record about, well, he could have picked other things, other charges when he was telling him, if you step out of that crosswalk, I'm going to kick your butt, or, you know, I'm going to bash your head in, or I'm going to do this, or, you know, stalking. I would say to the officer's credit, if you look at which one, he picked the class 3 misdemeanor out of those, if you're picking and choosing as far as it went with the deputy. I mean, the defendant, when the officer was standing there. And it wasn't a short, this was not some guy like the Washington case that he cites too, where some guy is charging a cell phone sitting on the sidewalk. And the cop says, oh, he looks shady, I'll go encounter him. The officer was not the one who initiated the encounters. Matter of fact, he ignored him, he brushed him off, he kept coming back. It was 30 to 40 minutes of this, of him going back and forth. And if you look at the video, I think since we referenced that, when he says, he points, the officer points to the pizza place, to the door. He doesn't say, you know, back and forth. He says back and forth, but he points directly to the pizza place and harassing the patrons. I think, Judge Dillon, you hit on the main point here, is he's got to be right. I don't think he has to be right, but I think he can be mistaken, Hahn. I think he can still have probable cause to arrest. That question was put directly to the jury. The charge was given. They came back. Out of the charges on the indictments, they did not go with the second assault against the other officer for the groin grab, and they did not go with the underlying trespass. But the probable cause was put to the jury. The jury believed there was probable cause to arrest and then went to the assault on Sergeant Tullis. So I understand that what we would like to do is sit here and decide whether there was sufficient evidence for the charge on the trespass, but that's not really in front of you. I mean, I don't know that this is the case to make the law on where the sidewalk starts and stops in Asheville. I can see that the officer would understand that a business that had hired him, that he had gone in and out of at least 2 times, I think, according to testimony, to tell the owner what was going on outside. And during the times he was inside, the defendant is coming up and peering in the window. The officer would have believed that he probably didn't go into some analysis over curtilage and whether the business had the curtilage or not, but I am sure he believed that the defendant was on the premises of the pizza place. I mean, his understanding seems to be that this guy was hanging out right in front of and so intimately connected with the business that he could charge him with trespass. And I think that's reasonable. I think most of us would consider that a business and what's right in front of it, there's some connection to it. Because, you know, you see businesses all the time having to clean up in front of their business, snow, ice, keeping things clear in and out. I think there was testimony that he said that he was harassing people who were going into the pizza place. So your point about ingress and egress being blocked, he was there. I'm not sure that I'm not sure that you could grab a case out of anything I've seen and say this is apples and apples. I think we do have a situation here, if you were trying to go with a second-degree trespass charge to find out whether this conduct would sustain that, which the jury didn't convict him of, we would have a case and say, there's the case right there, we point to it. I think we've got a lot of cases around that. But if you're talking about the assault charges and the malicious conduct, I think we've got enough there. I think that's proper.
How would you answer his comment that this was one transaction, so maybe judgment should have been arrested on one of them?
I would differ from his comment about the resisting. If you look at the video and you listen to the testimony, the officer had put up with a whole lot of verbal abuse up until that point. And if you watch the video, he walks up to him and says, put your hands out. And he puts his hands out and he puts the cuffs on. And then he starts resisting. And then he says, then he kicks him. And he says, okay, that's an assault on a public officer or a public official. And he says, well, take it. He doesn't say, hey, man, you can't arrest me. I wasn't doing nothing. You know, there's no just a common sense approach to say, hey, you can't charge me with that. I'm just standing on the sidewalk. And then he turns around and spits on the officer and says, ask him how he likes that. I don't think that the distinction, I think Judge Gore pointed this out, the officers weren't kicking him. They weren't manhandling. They were restraining him to the degree that he was.
What was the conduct he was convicted of? He was convicted of resisting, and then what were the assaults he was convicted of?
The assault was the kicking on the.
Not for spitting, but when he kicked.
That was the malicious conduct, yes.
He was convicted of that too.
He was not convicted of the assault of grabbing the other officer's groin.
But just of kicking, for spitting, and resisting generally. So he's convicted of 3 different crimes.
Yes, sir.
Okay.
So based on that, I think you can't look at this of some kind of, if there's an underlying current of a bum's rush, you know, to get somebody off the sidewalk and move them on down the road. He obviously gave him the opportunity to walk down the sidewalk and use the sidewalk, but it was his conduct that was driving the officer to do something.
What was the conduct that was the resisting that was apart from the kicking?
If you look at the very beginning, when he's got his hands behind him, he's struggling, and he's saying, and he's not saying anything, he's just struggling, and they actually say to him, quit resisting. Because I think there's some case law that says that once you're under arrest, you have a duty to submit to the arrest.
Right.
And which he was not doing. That's the resisting part, is not submitting to the arrest. But when he starts kicking the officer behind him, then he's going into the assault. I understand that we've got notions of this break between time, between something, and it has to be yay so long, whatever time that might be. But when you've threatened to bash somebody's head in and kick their butt, and then all of a sudden you start kicking them, I think you've crossed over into the realm of the assault territory. I don't think that's resisting, particularly when it's accompanied by the verbal comments that he made at the time. We'll take it, and how you like that. That was not comments of, you got the wrong guy, I didn't do anything, I have every right to be here, you can't arrest me for this. It was very personal to the officers. It was an assault on the officers. It wasn't some general plea for getting out of a situation where he'd been arrested. I think the whole conduct of it tempers the view that the officer had, and I think it justified the officer doing something. Again, that charge did not lead to a conviction, and it's not in front of us as far as should it be sustained as far as a conviction.
So when he kicked the officer, he made a statement that, how do you like that? Is that what you're saying?
He was told, and my photographic memory of a video is not that great, but I encourage you to go look at it. But at the time when he kicked him, Sergeant tells us, the sergeant said, that's an assault on a government officer. And he says, we'll take it. Then he turns around to him, he's handcuffed, he turns around and he spits on the sergeant and says something along the lines of, "Do you like it?" So those two actions were there. And I don't think that's proportionate to anything to a small, what had been a very calm interaction with police with him. I mean, it was escalated to the point on his side where they put him in a car that had a cage in it because the officer testified they were afraid he was going to kick the windows out of another car if they tried to put him in it. This was not just a general protest, it was a very violent actions against the officers, and they were doing what they needed to do to protect their safety, including putting the T-shirt over his head so he couldn't spit anymore. Any further questions? Thank you.
Okay. Thank you.
Thank you.
You have 6 minutes.
I would just like to touch briefly on a couple things that were said. One, I don't think the defendant needs to know they're being unlawfully arrested for them to resist an unlawful arrest. Whether the defendant realized it was lawful or unlawful is not relevant to the inquiry. The second thing I wanted to point out was that the indictment in this case alleged that the resistance was fighting. And that's a very specific allegation. The kick was the allegation in the assault. Fighting was the actual allegation in the indictment for resisting arrest. They didn't allege that he resisted by pulling away or by delaying the proceedings. They alleged that he resisted by fighting.
And the only fighting move he made was kicking. So that's the same, that would be the same, that's what you're arguing. I'm just making sure.
That is essentially the argument, but that
I
the
got
entire resistance was a fight.
So are you saying there was no evidence of any other type of fighting at all, counsel? Or are you saying that that should be only considered, the kick was a fighting? Because I think in the record there was some pulling away, so I'm trying to make sure I'm hearing what you're saying.
Okay.
What was the totality of the fighting?
Well, the specific allegation in the indictment was that it was fighting.
Yes.
And I don't think he could be convicted of resisting by pulling away. And so when they alleged that the resisting was fighting, and then they alleged that the assault was a kick, they essentially made it so they could never prove separate conduct under due.
You're not,
Because there's one basic assault at this point.
you're not contending that they actually have to delineate what fighting actually was. I mean, he pulled away, he kicked the officers, he tried to punch. You're not contending that that would be required, are you?
No, what I'm saying is that essentially this resistance cannot be delineated from the assault. And if you look at the cases from this court and the Supreme Court from the 70s on this question, they involve even more protracted facts than the facts under this case. Extremely long engagements where the person's captured, they're assaulted, there's fighting, they escape, they're recaptured, and our Supreme Court in those cases said that you can't be convicted of both. The last thing I would remind the court of is that when an officer unlawfully arrests an individual, that itself is an assault. An officer who arrests you illegally is essentially assaulting a private citizen in their private capacity, because having done an unlawful arrest, they're stripped of their legal authority to take you into custody. So when you talk about the proportionality of the resistance, you have to consider that an unlawful arrest is itself an assault.
All right, well, counsel, get me to the proportionality of the spitting then. If we're talking about proportionality, because clearly, I get your argument that that is in and of itself an unlawful arrest is an assault, but I think spitting is a whole nother ballgame. Get me to that proportionality, because I don't think I've heard anything as of yet to get me to that level of what law enforcement has done to warrant a spit to have it equal.
Okay, so I will touch on that very briefly, because the malicious conduct by a prisoner does not have a proportionality element to it. The defense in this case is that the individual cannot have been in custody when they were unlawfully arrested. Absent a lawful custody, there can be no malicious conduct by a prisoner. And he was never charged with an assault by spitting.
Is assault on a government official or an assault the lesser of malicious conduct by a prisoner? Have you looked that up?
I don't believe it would be because they would have separate elements, I believe. Assault on a government official would not require custody, for instance, and an assault wouldn't require spitting, for instance. So having separate elements, they would fail the Blockberger test.
So with those facts, hypothetically, assuming following your line of thinking, would that not still fall within some level of resisting that he wasn't convicted of, but wouldn't that still be considered some level of resisting, even though it might be, over proportional?
Well, I would disagree that it's disproportionate in terms of the resistance and stand by the fact that proportionality is not an issue with malicious conduct by a prisoner. But I think the essential question is here whether there was lawful custody to begin with.
Mr. Yoder, let me ask you a question that your colleague brought up. He proposed that the question of probable cause to arrest was in fact put to the jury. Do you concede that probable cause to arrest was actually put to the jury?
Well, it was put to the jury, but the mere fact that a jury might later return a verdict of guilty does not mean that there was not insufficient evidence. We have plenty of cases. The essence of the question here is whether the case should have gone to the jury at all, not whether the jury could have, or not whether the jury did ultimately return a guilty verdict or not. But I think to Judge Dillon's comment, it's not clear whether they did find that it was a reasonable arrest, or there was probable cause to arrest, or whether they possibly thought it was not a lawful arrest with disproportionate resistance. But our contention is here that it's both an unlawful arrest without probable cause and that the resistance was proportionate, and having been unlawfully arrested, the charges should have been dismissed.
You want to take a minute to wrap up? That's fine, or if you're done, that's fine.
Unless the panel has any more questions, I think I'm done.
Well, thank you. We'll
Thank
take
you,
you under
Your Honor.
advisement. Thank you for your arguments. It's good to see you guys.
Thank you.
Ready to close?